Hi guys, it's Kathy. I hope you're doing well. We made it to OJ and I forgot to tell Discord that we are starting OJ. So I should do that real quick. So tomorrow, tomorrow I have an appointment at 8 a.m. And I was going to cut OJ short. I think instead I'm going to do the opposite. I think tomorrow is going to be an extra long OJ stream. I think I'm just going to let it run while I'm at my appointment. And, yeah, I think that's better than cutting it short. I think we let it run for a little bit so that we keep our timeline. You know what I mean? I have a timeline of when we finish this. And I haven't told you, because remember, we did a vote to see if you wanted to see when OJ was going to end. And the vote was no. But I still know when it's going to end. So, if I let it run, we'll make my timeline, maybe even beat it. We should beat it anyway, because I didn't really factor in sidebars. So, every time I fast forward through a sidebar, cuts my deadline down a little bit. But, yeah, tomorrow's going to be an extra long OJ marathon. I'll talk about it tonight during my live stream. If anybody remembers, tonight at 8 o'clock during my live stream, and I don't, maybe remind me to tell everybody. Maybe, I don't know. All right, but let's press play. Make sure we have sound, and we.
Simpson matter. All parties are again present.
There we go.
Jury is not present. Mr. Blazer?
Yes, Your Honor, two things. I asked the prosecution right after we broke if I could talk to Mr. Lee, Mr. Schott's attorney, as I may want to ask him one or two more questions, and I'm waiting for that. Also, I asked LAPD to bring over item 94, which was a glove taken from Mr. Simpson's residence, that I'd like to have lodged with the court. I don't know if I'll use it, but Detective Van Etter needs it to be lodged with the court so he can account for it.
Okay. We'll mark the glove then. Ms. Clark will mark it People's 609 for identification purposes. 609. Yes, please, Detective. Thank you. And is it a glove or a pair of gloves?
A glove.
A glove. A glove. A glove and paper bag. Do you want to see that first?
Yeah, I bagged it.
Ms. Clark, have you seen the contents?
Yeah, a long time ago. We all have.
We filed P&As on Dr. Dutton's testimony with the court. I think Mr. Bailey has some counsel. I just want to know when the court wants to address that matter. Is it with the other?
Haven't even seen it yet.
No, I
Just got
understand.
it.
This afternoon?
I'll take a look at it at the conclusion of the court day, see what it is, and see when it is I want to do it.
So not this afternoon?
No, not this afternoon. We have RFLP set for this afternoon. All right, Ms. Clark, is Mr. Lee available to chat with Mr. Blazer before we move on?
Yes, Your Honor. I asked immediately at the break when Mr. Blazer informed me he insisted on speaking to him that I asked that he be called down, and it just took a while, but he's coming down and he can speak to Mr. Blazer.
All right, Mr. Blazer, you want to chat with him briefly before you move on?
Yes, also, if we could have the next witness so I can make my cumulative objection.
Okay, Mr. Blazer's saying that, Your Honor, because I already told him that I would, I voluntarily have eliminated 3 more witnesses to black gloves. And I would propose to conclude the glove presentation with Stuart West and Mike Romano and Deborah Gadara.
All right, are these all brown glove people?
No, 2 are black glove and the last one is brown glove.
All right, why are we doing black gloves?
Because those particular photographs show a fit that is very significant for the witness, Richard Rubin. These are very brief. Neither one of them involves video. and they're very late in time. One's December of 93, the other one's January 94. We've already, you know something, Your Honor, we have eliminated from our list now 7 witnesses that we had proposed to call, because the court keeps indicating that it's going to rule these things cumulative. We have pared it back now to the very bare bones. This testimony is not, in fact, taking very long. But
Be
we
that
need-
as it may, it still doesn't mean it's not cumulative. One, we got brown gloves, not black gloves. I mean, wouldn't you have put on your most recent black glove person first?
No, I didn't, because I need to lay a foundation in the beginning and at the end, Your Honor. No, this is important. This is important, Your Honor, because Nicole Brown bought him these gloves in December of 90, that's right. She bought them on December 18th of 1990. It is important to show him wearing the gloves close to the date of purchase as well as close to the date of the murders, and that's what we are attempting to do, is to show a course of wearing these gloves from the time that they were purchased to the time of the murders, and that's obviously important, Your Honor.
Do they have an early one? And Mr. Schott is December of 93. That's a late one. You have 2 sets of black pictures.
That's November of 93, not December.
Okay.
What's your latest black glove?
May I show you the photographs we want to show, Your Honor?
What is your latest black glove, counsel?
January 94.
And who is that?
That's Mr. Romano. And it's important, may I show you, Your Honor, the photographs that we have?
Well,
There's only-
why do we need, first of all, the gloves that are in evidence are the brown gloves, not the black gloves.
I understand that, Your Honor. But the nature of the fit is very important, obviously, in this case. And I would like to show you the photographs we're talking about so you will appreciate what I mean.
Thank you. All right, which one is which? One, Mr. Simpson appears to be wearing an NBC turtleneck.
The horizontal photograph in which he's wearing the turtleneck that's taken indoors is the January 94 photograph. And you can see the Aris label in it. You can also see the cashmere lining in that photograph.
I dispute. You can see the label, but they're black.
All right, now the vertical photographs where Mr. Simpson appears to be holding a lineup, and it appears he's putting the gloves on or taking the gloves off.
No, Your Honor, he has one hand against his chest and it shows the very short and tight fit of that glove. The other hand is in front of it holding papers. And that's December of 94.
You can see that bunched around his wrist, and he's pushing the fingers in. I mean,
One hand is not touching the other.
it's the black one.
Also, you should note on the wrist of that particular photograph, Your Honor, you can see the kind of stitching which is important to the testimony of Richard Rubin, the expert on this matter. And the bunching that Mr. Glazier continually refers to is going to be explained by Mr. Rubin as well, as being reflective of the fact that it's very thin leather that rolls and puckers, which is consistent with the Harris-like glove. I would also point out to the court that those 2 photographs that are most close in time to the murders of the black gloves show features that none of the other ones do, both of them. They show the manner of the gift and the stitching of the wrist area, as well as the lining and on the other photograph, the lining and the Aris-like tag.
Sounds like they saved what they thought was the most probative for last to avoid the cumulative objection.
No, Your
To me.
Honor, we're showing evidence of wearing these gloves that is consistent over a period of time, both early on and late on. Obviously, there are a great deal more we could have shown, but we voluntarily excised them from our presentation. And if you look at the photographs that we've already presented, Your Honor, they show the hand in various positions, one with the palm out, one with the palm closed, which shows the fit when the fist is closed. And shows how short, in another set of photographs, shows how short it is on the wrist.
All right, the one that is the horizontal photograph that has the label coming out, the one that depicts the wrist area and what appears to be the lining, that is a different perspective than the others.
The other black photograph, Your Honor, is also a different perspective from the others. Showing the stitching on the wrist It's very important because we have two sets of gloves purchased in December of 1990 of the same type. And this ability to identify both the black and the brown gloves in these photographs as the same type is of obvious probative value. To the extent that the court cuts photographs out, because the court is chipping away from the credibility of the witness.
Christy, hello. Hi, Bobby.
What other witnesses do you have with
I
brown
need
gloves?
coffee.
One more witness on brown gloves. Plus video.
I haven't seen any video. I think
What-
that's part of the ton of video that's expected.
What video is this?
The Gadara, the same game that Ms. Gadara is going to testify about, I still don't have that. I don't think I have it.
All right, is Mr. Lee here?
I believe Mr. Lee is here.
All right.
May I indicate to the court, the videotape we're talking about was subpoenaed.
Well,
It's already,
let's not,
All right.
let me figure these things out first. All right, Ms. Clark, do you anticipate the direct examination will be the same, 5 minutes?
That's
Did
right,
you
Your
take
Honor.
these photos where and when?
exactly.
5 questions?
That's right. There's no video with these, it's just pictures.
All right, I'll overrule the objection. They do show different perspectives,
Thank you,
especially
Your
the
Honor.
label. All right, Mr. Blaze, you want to take a few moments to talk to Mr. Lee? And for the record, Ms. Clark, who are the witnesses that you've excised?
Yes, for the record. Aaron Brown, Jim Chegia, Robert Sieg. That was most recently. Prior to that, Flash Gordon Bama, Richard Roman. Christmas. I forgot the first name. Last name is Kristen, Your Honor.
All right, is Mr. Schott available in the event Mr. Blazer wants to recall him?
I believe so. I believe upstairs.
How about in an abundance of caution, why don't we have him escorted down so we can save some time in the event Mr. Blazer wants to recall him for a question or two?
Sure.
Mr. Fairlow, why don't you accomplish that? Mrs. Robertson? Waiting, can I see 608 again, please?
Is that 608A?
Any of them. Anything that has to do with 608. That's shot. I can't see, it's turned away. All right, thank you. All right.
I just lost the house. He just listed it as sold. Son of a bitch. Oh well, there'll be another, right?
All right, Mr. Blazier?
Yes, Your Honor, I'm prepared to go to the next witness. However, we may wish to call Mr. Lee out of order so that he doesn't have to fly back at some other time, but we're still considering that.
Okay.
They
Well-
have a rebuttal if they think he's relevant. Let them make an offer.
All right, let's proceed.
Thank you.
Next witness.
People call Mr. Stewart West.
All right, let's have the jurors, please.
Let them do it on their dime.
Stuart West,
Yes, sir. Oh, I guess they need to adjourn.
minor detail. Gentlemen, please be seated. All right, let the record reflect that we've been rejoined by all the members of our jury panel. Ms. Clark, you may call your next witness.
Thank you, Your Honor. People call Mr. Stewart West.
All right, Mr. West, would you step over here next to the court reporter, please, and face the clerk?
Raise your right hand, please. You solemnly swear that the testimony you may give in trial is not to be before this court should be the truth, the whole truth, and nothing but the truth, so help you God. Yes, I do. Please have a seat. You will stand and state and spell your first and last name for the record.
All right, Mr. West, would you please state and spell your name?
My name is Stuart West, S-T-E-W-A-R-T-W-E-S-T.
Thank you, sir. Ms. Clark?
Mr. West, can you tell us if you are a professional photographer, sir?
I am not right now, no.
Were you at some time?
Yes, I was.
When?
Started in 1989
Until
until about November of last year.
94?
Yes.
Directing your attention, sir, to the date of December 25th, 1993. Can you tell us if you were a professional photographer at that time?
Yes, I was.
Can you tell us where you were on that date?
I was at Candlestick Park in San Francisco.
And for what purpose, sir?
I was taking pictures of the San Francisco 49ers Houston Oilers game.
And where were you in terms of in the stadium?
I was on the sideline on the 49ers side.
So were you on the level on the field itself?
Yes, I was.
Did you see the defendant there when you were there?
Yes, I did.
About how far away from him were you?
I was approximately 30 feet away from him.
And he was on the field as well, I take it.
Yes, he was.
Was there any artificial lighting at that time?
Not that I remember, no.
And you took photographs of him at that game?
Yes, I did.
Your Honor, I have here a photograph that I'd like to be marked People 610.
All right, people, 610.
A small photograph, sir, showing you People 610. Can you tell us if you recognize what I've shown you?
Yes, I do.
What is that?
That is my photograph.
Is that the photograph you took of the defendant on December 25th, 1993?
Yes, it is.
And did you send it into the district attorney's office, sir?
Yes, I did.
May I put it on the envelope, Your Honor?
You may.
I have here, Your Honor, two enlargements. I'd ask you to mark People 610A. First one is 610A, shows the defendant It's an enlargement of photo 610, Your Honor. Show you People 610A and ask you if you recognize what's shown there.
Yes, I do.
What is that?
That is a photograph that I have taken.
And is that an enlargement of the photograph that was shown to you just now that's up on the screen as People 610?
Yes, it is.
True and accurate copies, are they, sir?
Yes.
Showing you People 610B, does that appear to be a further enlargement, focusing in more on the gloves of the same photograph?
Yes, it is.
Also a true and accurate copy of your photograph, sir?
Yes, ma'am.
And did you send the negatives to the district attorney's office for authentication to make sure that these were accurate photographs?
Yes, I did.
All right, Your Honor, I just simply ask that these be affixed to the board, the photograph 610 and A and B with label.
All right, what's shown Mr. Blazier first?
The label indicating, Your Honor, Stewart West, 12/25/1993, 49ers versus the Oilers.
Yes.
Thank you, Your Honor. And this game, was it played in San Francisco, sir?
Yes.
Anything else?
Mr. Blazier?
Thank you, Your Honor. Good afternoon, Mr. West. How are you?
Fine, thank you.
Mr. West, I ask you to take a look at the blow-up on the board here. And can you see in the picture where the right glove appears to be tucked under around the wrist area, or actually above the wrist area?
Yes, I can.
You have no way of knowing from this photograph how far that's tucked under, do you?
No, I don't.
Do you have any pictures showing the inside of the glove?
No, I don't.
Any showing any labels?
No.
Any lining?
No,
Now, you provided the prosecution with another picture in addition to this one, didn't you?
that's correct.
All right, I'd like to have this marked as defendant's next.
I'm sorry? 1371.
Mr. Blazier was one that doesn't have holding.
Thank you.
Now, Mr. West, take a look at 1371. Is that a picture of the same gloves?
Yes, it is.
Same day?
Yes.
Around the same time?
Yes.
Can I put this on the envelope, please, Your Honor?
You may.
Mr. West, you see how the gloves go all the way back on the wrist?
Yes, I do.
Objection, that's all conclusion.
Overruled.
Call for speculation, Your Honor.
Overruled.
Prosecution tell you they were only going to put in one of your pictures?
No.
Objection.
No further questions. But, I'm sorry.
Didn't the court rule that some people are cumulative?
Overruled.
Yeah, mid-turn. One final question. These are black gloves, aren't they?
As far as I can tell, yes.
Thank you.
Any redirect? All right, Mr. West, thank you very much for coming in. Your excuse, sir. Ms. Clark?
Thank you. Your Honor, Mr. Fairwell, please put the small photograph up on the board as well, just people 610.
Yes.
Thank you. People call Mike Romano.
All right, Mr. Romano, would you come over here and stand by the court reporter, please? And face the clerk.
Raise your right hand, please. You do solemnly swear that the testimony you may give in class now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Please have a seat in the witness stand and state before your first and last name for the record.
Michael Romano, Michaelromano.
All right, Mr. Romano, just sit back and why don't you pull the microphone closer, please? Thank you, sir. Ms. Clark?
All right, Mr. Romano, are you a freelance, are you a photographer, sir?
Yes, I am.
And what kind of photographer are you?
Freelance photographer.
And directing your attention, sir, to the date of January the 15th, 1994, what was your occupation at that time?
I was a photographer.
And on January 15th, 1994, sir, where were you?
I was in Buffalo, New York.
And why were you there?
I was photographing the Los Angeles Raiders football game against the Buffalo Bills.
Can you tell us, sir, if you took any photographs of the defendant on that date, in January of 1994?
Yes, I did.
And where did you take photographs of him?
I shot a photograph in the media room after the football game.
And where is the media room, sir?
The media room is adjacent to the locker room where they bring the players after the game.
And now the photograph that you took of the defendant, did you sell that photograph to someone, sir?
Yes, I did.
Who'd you sell it to?
The National Enquirer.
Are you here under subpoena, sir?
Yes, I am.
You did not ask to come here, is that right?
No, I did not.
I'm going to show you a photograph, Your Honor, People's 611 and 611A.
611, 611A.
Showing you People's 611, sir. Can you tell us if you recognize the photograph that I'm showing you?
Yes, I do.
And what is that?
That is the photograph that I shot.
And you shot this photograph, you told us, in the media room, that's just a room just outside the locker room.
Right. Where they hold post-game interviews.
Now, was that in New York?
Buffalo, New York.
And the photograph that's been marked people 611A, can you tell us if that is an enlargement of
Yeah.
the portion of the photograph in 611 that shows the defendant's left hand?
Yes, it is.
And is it an accurate enlargement, sir?
Yes, it is.
I may show this on the Elmo drawing.
You may. Which photograph is this?
611, first, Your Honor.
Mr. Romano, just look at your monitor and see if you recognize the photo. Ms. Clark.
Thank you. Now, this photograph, sir, is this a photograph you took of the defendant on January 15th, 1994, in the media room?
Yes, it is.
And how far away from him were you when you took this photograph, sir?
About a distance of 3 to 5 feet.
Showing you people 611A. From 3 to 5 feet away, sir, did you use a zoom lens then?
No, I didn't. I used a 50-millimeter lens.
Do you recall what time it was?
It was about 4:30 in the afternoon.
Did you use a flash, sir?
Yes, I did.
Do you recall what the film speed was?
200 ASA?
Now, did you send us negatives so that we could verify the accuracy of the print?
Yes, I did.
And when you sent your negatives to a lab for processing, did you ask for any special processing?
No, I don't.
Do you see? Strike that. I have nothing further.
Mr. Blazier?
Romano, good afternoon.
Good afternoon, sir.
This was in Buffalo
Buffalo, New York, yes.
in January of '94, correct?
Yes, it was.
What was the temperature?
It was about 35 below zero.
Very cold, wasn't it?
Very uncomfortable.
A lot of people wearing gloves?
Yes, sir.
A lot of people with hand warmers?
Yes, sir.
Kind of hand warmers that slip under a glove in the palm?
I wouldn't be able to see that, but I imagine.
So you have no way of knowing whether Mr. Simpson had one of those under his palm there, do you?
No, I don't.
Can we have that back on the Elmo, please? Now, those gloves are black, aren't they?
Yes.
The bulkiness around the fingers, is that consistent with your recollection of what they looked like at the time?
Yes.
And the rolled up area, the extra leather at the wrist there?
Sustain. Ms. Clark?
Sir, do you see that white oblong thing sticking out of the edge of the wrist area of that glove?
Yes, I do.
You see the arrow pointing to it, sir? Does
Yes, I do.
that appear to be the tag attached to the glove?
Speaks for itself.
Sustain.
What does that appear to be to you, sir?
Speculation.
You can answer the question.
It appears to be some sort of tag attached to the glove.
Can't read anything on that, can you?
Looking at the photograph, no, I can't read anything.
Is that it?
Yes, may I ask that these photographs also be attached to the board later, Your Honor?
Yes. All right. Do you have any further questions for Mr. Romano?
Nothing further.
Mr. Blazier, anything else for Mr. Romano?
No.
All right, Mr. Romano, thank you very much for coming out, sir.
Thank you.
People call Mr. Deborah Guerra.
All right.
Ms.
You did. All right, Ms. Gudera. All right, would you step around here, please? Stand over by the court reporter and face the clerk.
Raise your hand, please. Do you solemnly swear that the testimony you may give in the cause not pleaded before this court will be the truth, the whole truth, and nothing but the truth, so help you God? I do. Please have a seat in the witness stand. Please take the photo first, and the same for the record.
Deborah Guidera, Debraguidera.
Ms. Clark?
Thank you, Your Honor. Ms. Guidera, can you tell us, are you a professional photographer, ma'am?
No,
Have you ever been one?
no.
Directing your attention, ma'am, to the date of December 12th, 1993. Can you tell us where you were on that date?
I was at Giant Stadium in East Rutherford, New Jersey.
And why were you there?
I was helping out a friend as a photo messenger that day.
Can you tell us what the weather was like that day?
It was very cold.
Now, while you were there, the friend that you were helping, what did he do there?
He works for the Associated Press.
Was he a photographer?
Yes.
And can you tell us where you were in the stadium?
I was on the football field.
Were you at the sidelines?
Yes.
On whose side?
On both sides. Oh, actually, on the Colts side. As when I took the picture.
Okay. Now, when you say the picture, did you have a camera with you that day?
I did, but it wasn't mine.
Whose was it?
It was my friend's.
Now, I have here a photograph, Your Honor, asked that it be marked People 612,
All right, 612,
and then there'll be two enlargements.
612A and B.
Yes, thank you, Your Honor. The farther away enlargement, 612A, close up on the hand area, 612B.
So marked.
Thank you. Ms. Guidera, I'm going to show you a photograph that's been marked as People's 612 and ask if you recognize this photograph.
Yes, I do.
Is that a photograph that you took now?
Yes.
And is it a photograph that you took on December 12th, 1993 in New Jersey in the Giant Stadium?
Yes.
And do you recognize the person depicted in that photograph?
Yes.
Who is it?
O.J. Simpson.
And how far away from him were you when you took that picture, if you recall?
I would say about 10, 12 feet.
Can you tell us what color gloves are depicted in this photograph?
They look dark brown.
All right, you place 612 on the elbow.
They look dark brown or black.
I'm going to show you what's been marked now as People 612A and 612B. Do these appear to be enlargements of the photograph that you see here in 612?
Yes.
And are they accurate enlargements of the photographs you sent us?
Yes.
Now, you indicate that you were approximately 12 feet away when you took this photograph?
Yes.
Certainly.
Your Honor, may I ask that the photograph marked People 612 be passed around?
All right, small photograph.
Yes, sir.
All right, hand that to juror number one, please. Juror number one.
May I ask that Mr. Ferretlow be permitted to put up the A and B?
Yes.
Thank you.
Would you collect the photograph 612 from Deputy Smith, please? Thank you.
And may you also fix that to the board, Your Honor.
You may.
Now, let me ask you a further question, Ms. Guidera, about the date. Do you independently recall what day it was?
It was Sunday.
It was a Sunday? Is that yes? You have to say it out loud for the record.
Yes.
Okay. And what month was it?
December.
Of 1993?
Yes.
And do you know if it was before or after Christmas?
Before Christmas.
And what date was it? What Sunday was it? Do you know?
The 12th.
Your Honor, the label that I have here indicates only 12 of 1993. May I ask that we be allowed to make a new label indicating 12/12/93 for the purpose, before we put it on the board?
Yes. you have any further questions for Ms. Scudero?
Very briefly. Ma'am, was there any artificial lighting when the photograph that you took of the defendant in those gloves on December 12, 1993 was taken?
No.
Did you use a flash?
No.
And did you send the negatives to us for the purpose of verifying the accuracy of the photograph?
Yes, I did.
Mr. Blazier? Yes, you may. All right, let's have a quiet, please. All right, Mr. Blazier, you ready to cross-examine?
Yes, sir. Good afternoon, Ms. Scudero.
Hi.
How are you?
Okay.
This was a December in 1993 in San Francisco, correct?
No.
I'm sorry, in New York,
No, New Jersey.
New Jersey. How cold was it?
Very cold.
Very cold. A lot of people wearing gloves there?
I guess so.
Not particularly unusual to see people wearing gloves at a football game?
Oh, well.
No, it's not unusual.
Okay. Now, I want to take, I'd like to remove one of these if I might. And can I put this on the envelope, please?
And which one is this, Mr. Blazier?
This is 612, I don't know. A. Can we back out on that, please? Now, Ms. Gadara, do you have an independent recollection of being there and seeing Mr. Simpson
Yes.
and looking at him when you took the picture?
Yes.
When you looked at that glove in person, was it as loose as it appears to be in the picture?
Oh, well.
I can't recall.
Okay. The picture is the best record of what you saw. Now,
Yes. You were shaking your head. Is that
Repeat the question?
this picture is your best depiction of what you saw that day.
Yes.
Okay. Now, could we have the back up just a little more? And could we have, zoom in on in the lower right corner? More. Okay. And could we have a circle around that glove, please? Ms. Gadara, do you recall seeing the person standing behind Mr. Simpson wearing gloves?
Right now I do, yes.
They appear to be the same kind of gloves that he was wearing?
I don't think so.
May we have that printed out, please?
Yes. We'll mark that as, let's make that 612 C.
I'd like to show the witness people six.
Staying. Records reflect that the reference was made to 609. 609. Ms. Clark, any redirect from Ms. Gadara? All right, Ms. Gadara, thank you very much for coming in. You're excused. Next witness.
Richard Rubin, the glove man.
All right, let me see counsel at the sidebar without the court reporter. Gentlemen, there's something I need to take a look at before we hit the next witness. Let me ask you to step back into the jury room. All right, the record should reflect all the jurors are withdrawn from the courtroom. Ms. Clark, you indicated you have a compact disc-based video. May I see that, please?
Yes.
All right, let's clear the telestrator, please. All right, Mr. Orman, I don't have anything on my monitor. Mr. Blazer, do you have this on your monitor? Ah. Please. Appears to be a different clip.
That was the end of the sentence.
Ms. Clark.
The shot of the defendant in the brown coat with the brown gloves is the one that we do not have, I believe, in the cinematographer report.
It's pretty good digital quality.
The detail that's shown in this video, though, was important to Mr. Rubin for the purpose of determining whether the stitching was consistent with the stitching of the crime scene.
Your Honor, may we have Mr. Rubin leave, please?
Yes, Mr. Rubin, why don't you wait outside?
Mr. Rubin would like to be here when we discuss the issue of scheduling, however.
Scheduling? Sure. Yeah, why don't you just wait outside, Mr. Rubin? Thank you. All right, Ms. Clark, as to record to reflect that Mr. Rubin's withdrawn from the courtroom, with regards to this 15-minute clip that's on the compact, is it a laser disc or compact disc?
It's on a laser disc.
All right. Objection?
Yeah, I checked. First of all, it's cumulative. It's another brown glove. I don't think it shows anything more than what they've already put pictures on. I don't know. Object to the foundation. They haven't established the foundation. So I object on both of those grounds. Don't know when it is.
Let me get that for you, Your Honor. But let me simply, but let me indicate this to the court. I understand the objections to cumulative nature in the black glove, and we pared that down considerably, but all shots of the brown gloves that are deemed to be, by our expert, consistent with those purchased by Nicole Brown and those found at the crime scene and at Rockingham are clearly not cumulative, because it shows the defendant not only having them at a point in time shortly after they were purchased, but also at a point in time, also shows his habit and custom of wearing them, which means they're out in the weather. The more he wears them, the more important that is to their stretchability, and as close as possible in time to the murders. This clip that is shown in the brown gloves is of the Kansas City versus the Bills on January 5th, 1992.
And there's a lot of pauses. I hope now that they got all that, there's not a lot of pauses. Let's just peek. I can't tell it. You guys might have to sit through a bunch of pauses while I'm gone, but I'll be back as soon as I can. All right? Behave.
It's an important video for the expert because, as the court can tell, it's very clear in its depiction of the nature of the stitching on the fingers, the Brother stitching on the back of the hand, and these are distinctive features to be able to identify these gloves as the type and class purchased by Nicole, and coincidentally, the type and classification of gloves found at Rockingham and Bundy. I don't know what other justification needs to be
Well, I
made.
understand the justification. How are you going to lay the foundation for it? I recognize the person depicted. The question is when.
Right. And for that purpose, Your Honor, we subpoenaed the representative from NBC. NBC responded by sending an affidavit to the court. I believe the court is in possession of that?
Yes,
And then-
received it this morning.
Yes. If I may ask leave of the court to ask Mr. Yokelson to come down to indicate to the court, because he's had all the interaction with them, they've been very uncooperative. I would ask that the court inquire of Mr. Yokelson, because it's my understanding that the attorney, Ms. Edgerton, has indicated that her position on behalf of NBC is that the court can force the parties to stipulate to the admissibility of the clip without the necessity of a custodian appearing. And we have indicated to her the contrary repeatedly.
Well, federal courts can in civil cases.
Pardon?
Never mind.
Anyway, may I ask leave of the court to have Mr. Yokelson address the issue, since he has been in contact with them?
Because I think foundation is going to be necessary, at least place and time.
And I don't disagree. I totally agree with the court. We're being hamstrung by witnesses that are simply refusing to come in and testify. And we need the court's
Well,
assistance.
how about if I turn off the video, and let's see how long it takes NBC to cooperate.
I bet it'll work.
All right. Well, let's do it.
Okay.
Okay.
In the
where's-
meantime,
Where's Mr. Yokelson?
let me get him down.
All right.
He's on his way.
All right.
Make sure that it's on his way, but he specifically asked that he address you.
All right. Mrs. Robertson? Mrs. Robertson, have we heard from Miss Edgerton lately? Mrs. Robertson? Particular affidavit for a Mark Laplace concerning the particular outtake that you're discussing here?
The brown blood photograph, rather?
Yes.
Oh, yeah, the video.
Yes, the one that you just showed me.
I'll wait for Mr. Yolson to bring it down. I think he's in possession of all of that.
All right, do you know what game this is? I'm sorry. Which football game is this?
It is Kansas City. Is it Kansas City? Yeah, Kansas City Chiefs versus the Bills
On what date?
on January 5th, 1992.
Now, the fact that this is all right, what's the source of this? All right, records reflect we've now been rejoined by Mr. Yokelson. Good afternoon. Mr. Yokelson, there is some controversy about the foundation for the video clip, which is alleged to depict the January 5th, 1992 football game, American Football Conference playoff game between the Chiefs and the Bills.
Yes, Your Honor. As Ms. Clark indicated, we did subpoena that footage from NBC. NBC provided that videotape in a fairly expeditious manner, and at the same time provided a custodian, or offered to provide a custodian of record affidavit. They did not, and their position has been throughout this, that they are not obligated to provide an actual live witness. Their position is that the witness who would testify to this is located in New York and beyond this court's jurisdiction without further process of the court. Ms. Edgerton filed a letter with the court today, and I just got off the phone with her, and she's indicated that she attempted to contact the court within the last hour, leaving voicemail. But she is attempting to, or strike that. She has contacted the court with this. It is our position, Your Honor, that the affidavit under 1560 of the Evidence Code should suffice to lay the foundation for this videotape.
Mr. Blazer, what's the defendant's position?
Our position is that we don't think that does. It doesn't comply with the law. This is not a governmental agency. That they have subpoena power. They can bring somebody from New York, just like we brought Miss McKinney from Georgia or from North Carolina.
All right, the problem I have, Mr. Yokelson, is that the affidavit, I agree with you that there is a manner, the subpoena ducis tecum and the process and the declaration of the custodian of records, that that's ordinarily a way to avoid having to call live witnesses if there are business records that are maintained in the normal course of business in an appropriate manner. The difficulty I have is that the declaration that is attached to Ms. Edgerton's letter to the court bearing today's date, the affidavit indicates, quote, NBC has made a diligent search for that footage and has not been able to locate it, and it refers to the videotapes of the Kansas City Chiefs Buffalo Bills game played on January 5, 1992. So the affidavit itself does not provide a foundation. So where does that leave us?
Well, that leaves us with attempting to find another affidavit, obtain a second affidavit remedying this defect, or having NBC here to explain this issue to the court. We are not going to rest until we can lay the foundation for a very simple piece of tape that should by rights be stipulated to, but the defense, we've not been able to arrive at a stipulation. It seems that this matter should be handled very expeditiously. Ms. Edgerton informs me that she can be here tomorrow, and I would ask that we have her in first thing tomorrow, and we attempt to hammer this out with all the parties and NBC.
Because we handle business records all the time in this manner, but the affidavit doesn't support what you're asking for.
Well, in that case, I'm sure that we can address that issue with NBC, and we will take it up. I suggest that we hold this matter in abeyance until tomorrow morning, have Ms. Edgerton in, and we will settle this matter.
Well, I would suggest that you have somebody up at 5 o'clock tomorrow morning at the opening of business on the East Coast and see if you can expedite this matter, because the matter of an appropriate declaration, that's all that's missing here.
It should be a simple thing, and we will accomplish that. Of course, as Ms. Clark points out, the fact is that NBC gave us this videotape, so clearly they knew what it was in response to our request, so clearly they knew what it was and were able to locate it.
Well, my problem is, Mr. Yokelson, as much as I understand and appreciate what it is you're saying, There's an objection, and the affidavit doesn't support what you're asking for.
All right.
Yeah, we have copies of what's been submitted. We haven't seen
Yes.
any.
Mrs. Robertson, would you have Mr. Byrne? I think you should.
I believe that was already provided previously, Your Honor.
Okay. All right, as far as scheduling, then, I take it then unless and until we have this video, this is also a videotape you want to use with Mr. Rubin, correct? All right, scheduling then. Mr. Blazer indicated he needed additional time to prepare for the cross-examination of Mr. Rubin, and Mr. Darden, you indicated that there was a desire to have Mr. Rubin present just so we can consult with his calendar. All right, why don't you ask him to step in, Mr. Fairlow?
Ask him to come in. I don't know that the court is aware of this, but Mr. Rubin is the only so-called expert in this entire case who has testified without any fee or free. He has appeared here on many occasions on his own time. He has taken calls from the defense on the East Coast on his own time. He runs a business, and he needs to get back to that business. I don't understand why we need to delay until Wednesday.
Well, there's a request for additional time, and part of the difficulty, though, is some of the information that Mr. Rubin produced and gave to the prosecution was not turned over to Mr. Blazer until today. I mean, that's not a situation that the court created.
Everything that we have put on today was turned over to the court. They were turned over, I believe, prior to September 1, Judge.
Well, we had a discussion. We started off this morning's discussion with the fact that Mr. Rubin's letter of July the 6th had not been disclosed to the defense. That's how we started off this morning's discussion.
And I think we ended that discussion by the court noting that it was a preliminary, at most, conclusion on his part. He was asking for more photographs or better photographs, and was
The point being, though, is that he
conclusion.
actually does refer to specific photographs and make certain findings. That's the point. All right, Mr. Blazer, why do you need until Wednesday?
Well, I think it was a total of 47 pictures on Friday afternoon at 5:30. I spent the weekend working on this. We may be producing some exhibits. I have to coordinate some other people that I may have here in court for when Mr. Rubin testifies. We simply just need some more time. I'm looking at Thursday. I may be able to be ready by Wednesday. I'll have a better idea tonight.
Well, specifically, what is it you need to do?
I need to consult with experts that we've been in contact with. I need to see if they're available to be here Wednesday. We may be making some photographic exhibits. I obviously been here all day, so I haven't been able to do that today. That takes time.
We gave them color copies of just about all the photographs early on. Your Honor. There's nothing that has been presented here today that should have been a surprise to the defense. This is rebuttal. We all knew it was coming. We all knew we were going into the glove issue. It's really a simple issue, that is the identity of these gloves being an Aris leather light, an Aris light, or not. How much more time can be necessary to prepare to cross-examine Rubin on these issues? Beyond that, we've already litigated the issue of brochure stitching and the V-palm and all these other things.
And what? I'm sorry.
We've already litigated these issues regarding the stitching and the V-palm and everything else as it relates to the uniqueness of that glove. So why the extra time?
Well, the main problem I have is that this report wasn't turned over.
A detailed, in fact, a transcript of our conversations with Mr. Rubin as they related to each of the photographs shown to him was provided to the defense on August 31st or September the 1st, on September the 1st, which is much more detailed than any report, and in particular much more detailed than any preliminary report or letter sent to him by us. They have a transcript of all of his opinions as they relate to each of the photographs, and they've had it for 12 days now.
My recollection of that transcript is the only photograph he said looks like the Aris glove to me is one Röntgen picture, maybe a second. That's it. None of these other ones are referred to in the transcript, and then there's one video I think that he said is a good video. None of what we've heard except for the Röntgen pictures is part of that transcript. Now, this is I'm assuming this is part of some later opinion, but I have nothing about that in writing. I just have to assume he's going to get up there and say something about it.
Mr. Darden, do you have a copy of your of Mr. Rubin's last report or letter to you? His final report or letter?
I don't believe we handed over a final report. We handed over the transcript of Mr. Rubin's opinions and comments as they related to each of the photographs. Mr. Rubin points out to me that it was Mrs. Blazer, Mr. Blazer's wife, who called him up and let him know he was coming back to testify in the first place, and that it was Mrs. Blazer who interviewed him on the telephone several days ago, on September 1st. So none of this is a secret, Judge.
Yeah, we had obviously we've been trying to prepare for this since they started making noises about doing this. We had no pictures when we talked to him before. It was a telephone conference. That's it. That was not terribly helpful.
Mr. Rubin would like to testify tomorrow morning and get back east to his business and family.
It does not give me adequate time to represent my client.
And I think that's probably why we have the objections, so that he'll be forced to go back east before he is allowed to testify in this case. This is a no-brainer, Judge. They've had adequate notice.
You people.
And I'm willing to surrender people's witness, Mr. Rubin, to Mr. Blazier. He may take him anywhere he may like and do with him whatever he may want.
All right, well, the photos are here. Mr. Rubin's here. Mr. Rubin's well known to both sides. He's been cooperative with both sides to an exceptional degree. He's provided raw materials for both sides. I think we've had the photographs now for a sufficient period of time. I am still concerned, however, about that letter of July the 6th. Mr. Blazier, be ready to go tomorrow.
May I say one further thing, Aaron?
Certainly.
One of the things that we've been doing is trying to accumulate gloves that have some of these characteristics, and we were going to do some photographs. We're going to attempt to. We can't do that, and I can just inform the court, I can't do that now. If I have to go forward tomorrow morning, I can't do that. We still have gloves coming too, by the way. So we may have to have him come back.
Well, that's something that can be independently put on by somebody else, by an investigator, that they found these gloves with similar characteristics. That's something you don't need to do with Mr. Rubin.
Well, we need to test
But this is also not an issue that's been a mystery or is unexpected.
Which photographs he's going to identify has been until today, except for the Rankin pictures.
All right. Anything else?
Yes, Your Honor.
Before we launch into our Sims hearing.
It's a discovery question concerning upcoming witnesses.
Yes. Who's coming up after Mr. Rubin?
Well, first of all, Your Honor, of the list of 60 names that we were given on Friday, my office has attempted to identify those witnesses for whom we have no report, statements, or any idea of what they are going to testify about.
All right, and they are?
David Atkins, I believe, works with SID, but I'm not sure of the nature of his testimony.
Who is David Atkins?
The OIC in the photo section at SID, I believe he testified once before on the issue of the Willie Ford video.
Yes. Press people say yes. They know who he is.
And if they will look at, did he testify? If you look at the logs from Rockingham, you see that he arrived at Rockingham around noon that day. He testified that he saw the socks.
Are there any reports regarding him?
I will.
I'm sorry to hear
I
you.
don't think so, no.
Next.
Brent Clayton, Clayton.
Who is Mr. Clayton? Ms. Clark, do you want to look at my list? All right, and before we break, Mr. Rubin, would you make yourself available to discuss these matters with Mr. Blazier this afternoon, this evening?
No problem.
All right, thank you, sir.
I'm drawing a blank at the moment.
All right, next name.
Jim Henson.
Paperwork, Your Honor. I have everything written down with who testifies to what and why, and I don't have it in front of me.
Let me get the name just so that we're clear. Steve
Okay.
Jensen. Dennis Kilcoyne, I know, is an investigator, a police officer. I'm not sure what he's testifying about. I have a name that says Laufman, Laufman, no first name. I don't know who that person is.
Mr. Laufman, I believe, was a witness to Kathy Randa and Skip Taft removing a large sum of cash from Mr. Simpson's safe deposit box on June 17th. And Mr. Jensen is from Cognitive. They enhanced the photographs of the gloves.
Lamar Lyle.
We did not do those enhancements.
I'm sorry, is that another glove witness?
No.
Okay.
Lamar Lyle.
But these are our witnesses to the established foundation.
All right, do me a huge favor. That's my list, so how about if you don't mark on it?
Shouldn't have brought that note.
Another one. Okay, how about, listen, what I'm going to do is I would like to take a brief recess because we're now going to launch into an hour-long hearing on Sims and RFLP. Let me order Mr. Douglas Mr. Darden and Ms. Clark to meet and confer during the recess, get your list, find out who's who, turn the names over to Mr. Douglas as to who you're going to call and who they are. All right, we'll take a, and that's what that includes.
I believe I stated all the witnesses the next 3 days on Friday, Your Honor. That's
All right.
I've already done that.
Oh, well, Mr. Fairlawn and Mr. Douglas get together, compare the names, the schedules. No, we don't need to do it. We don't need to do it again, counsel. I've got my notes. You should have yours.
One other thing, Your Honor. I wasn't here on Friday.
Okay.
One other thing, there's a motion, the people filed a motion to introduce expert testimony regarding domestic violence, which I thought we went through before. Dean Allman is here. He will not be able to respond to this motion until Friday, and we'd like to argue it next Monday. No, man.
Mr. Gordon is going to be arguing that issue for us, and we intend to rest by next Monday.
We'll rest without this witness too, then, Your Honor, because this week's got this convoluted, complex motion, which was already litigated, I thought, and Dean Allman is here, and it may require Kelly Fry, et cetera, and we're indicating we can't respond to it. His work is back up north. He's going back home. We'll respond to it by Friday. I want to alert the court to that.
You know, earlier today, Mr. Bailey told us he was ready to argue. He wanted to argue this motion this afternoon.
I don't think Mr. Bailey had seen this motion, Mr. Darden, at that point. This motion requires our points and authorities, and we will be doing that.
In fact, I think Mr. Bailey was ready to concede the issue.
Well, I don't.
I have not seen any points and authorities that were handed to me after. I said I'd be prepared to go on the papers I then had.
All right. Get your P's and A's as soon as you can. I think Friday's optimistic. All right. Let's take a 15-minute recess, and let's get the Sims witnesses down here, and we'll start into that. And Mr. Blazer, why don't you take advantage and chat with Mr. Rubin? All right. Which is the motion regarding RFLP testing of evidence taken from the Bronco automobile, and also some continuing issues regarding the scope of the prosecution rebuttal case. Mr. Cochran?
Yes, we would ask, we want to just make sure the court would allow us to argue the issues regarding the scope of the prosecution's case, because the case will be over. We may not have argued that motion. So I wanted to make sure we did that, at least
Well, then
not this afternoon.
wouldn't that indicate there's a very limited scope?
Well, you know, not left to them, Your Honor. I think you'd have to interject yourself to make sure that happens. So we'd like to do it sooner rather than later. So whether this afternoon or first thing in the morning, I just give Your Honor your choice on that. We're prepared to do that. I think counsel are prepared to do that as soon as you're ready. Bob Blazer has a portion of that, and I suppose he's out talking to Mr. Rubin. But I think Peter Neufeld is ready on a portion of it.
It would make sense, Your Honor, if we can schedule it this way. May I be heard?
Sure. Certainly.
Okay, thank you.
Good afternoon, sir.
Well, good afternoon, Your Honor. Mr. Scheck, of course, is going to be addressing the RFLP issue on the console this afternoon. And we just got, as you know, points and authorities this afternoon on the Dutton matter. But, for instance, you know, you asked the prosecution yesterday, are there any Kelly Fry cases at all involving this kind of testimony, you know, anywhere that would give the court guidance? And at that point, you know, Ms. Clark said, yes, I believe there are, but I'm not certain. We just spoke to, you know, Mr. Dutton this afternoon, and Mr. Dutton informs us, for instance, that as to these four matters, he's never participated in any Kelly Fry hearing anywhere in America or Canada on these issues before, that he wants to raise for the first time in this particular case. That's the kind of facts we need to know before we can adequately brief it and argue it before Your Honor. They said this case is going to last 3 to 5 days. 5 days. It's going to be the most extraordinary 5 days you know, since the Earth was created. All we're saying is that we need to know, before we start running off in 16 different directions, what evidence we're really going to have to refute, both in cross-examination and conceivably sir rebuttal. Yesterday, I also asked that they put in points and authorities, Your Honor, on June 17th testimony. I don't know if you recall that. Remember, they felt that June 17th was now relevant. Yet we haven't heard anything about June 17th.
Well, they offered, they indicated they wanted to call Skip Taft, Kathy Randa, and
Michael
Loft.
Baden and other people who were present at the house that day, but they didn't. There's no points and authorities as to what doors have been opened for that kind of testimony at this time. All I'm saying is this: I think we're entitled, as this train moves down the track, to get some understanding right away as to what the court is going to permit and what the court is not going to permit, so time is not expended on unnecessary issues.
All right, I agree with you wholeheartedly, Mr. Dufeld. So you're raising obviously the Dunton issue, which we just got a points and authorities on.
Yeah, Mr.
You're
Bailey.
concerned about the scope of the defendant's activities on 6/17, correct?
Yes.
All right. What else? What other concerns?
The
do you
Bronco
have?
Fiber report, which they feel that the door has been opened up because of a witness's suggestion.
Kathleen
that,
Bell.
right.
Yes.
I think Mr. Bailey will be ready to argue both those issues tomorrow morning, Your Honor. And I would ask that time be set aside tomorrow morning as to both the Bronco Fiber issue and also as to the Dutton matter tomorrow morning. Your Honor, also...
Dutton issue tomorrow is fine.
Okay.
No,
No.
just kidding.
Sorry,
Just
Your
kidding.
Honor, also, although we received a proffer yesterday with respect to, or I guess Friday, whatever it is, with respect to the scientific witnesses, most of the witnesses included on that list of 60 people are not expert witnesses, and they too have to fall within the criteria of proper rebuttal testimony. And so we can
Are there
argue
any
that.
particular areas that you can isolate for me that are apparent to you just from who they are?
Well, no, that's the problem, is that we have looked at that list, and there are many people on the list we've been unable to identify at this time. I can't tell you right now who they are. I can give you that tomorrow morning, and I would ask that first thing tomorrow morning when we give you that list, that the people then come forward with a brief proffer as to who those people are and what they'd be testifying to, so we can argue either in a 402 or 352 or whatever that it's inappropriate.
Makes sense.
So that can happen first thing tomorrow morning, too?
I don't know that it'll happen first thing tomorrow morning, but I at least want to frame the issues and get us scheduled
Okay.
to discuss these matters.
Also, you had mentioned that you were going to review the DeForest matter with Mr. Hodgman.
Had not heard back from Mr. Hodgman today, but in case you haven't noticed, I've been on the bench all day.
Okay.
All right.
One moment, Your Honor.
In fact, Mr. Kelberg, would you, in fact, Mrs. Robertson, would you instruct Mr. Hodgman to be here tomorrow morning, 8:30, so we can conclude the DeForest matter?
And also, we also want to be able to litigate this Paratus tape, which they've come forward with now.
All
Would you like, can we do that tomorrow morning also, so we'll know?
We'll schedule it tomorrow morning.
Okay. Thank you.
Before we begin with Mr. Sims, there's the matter of, it appears now to be Agent Diedrich and maybe Mr. Bodziak are the people's intended witnesses. The first matter I should raise, we just received this afternoon a document from the, documents from the FBI. It had previously been described to me by Mr. Goldberg as preliminary reports. I don't know if it's a preliminary or a final report. But basically, what has been done is they took some chemically treated paper and something that's called an identicator, and they took the genes.
I know we've had this discussion already.
Right. Now, I asked Mr. Goldberg again whether he would concede that the picture that I wanted to show to the court demonstrates that the genes are altered. Looking at the picture, it's clear that the genes are altered. He said he hasn't looked at it yet, and he maintains that the procedures that are being used to create these test impressions are not in any way a destructive test. And therefore, he takes the position that no notice need be given to the defense as to any of these testing procedures. That apparently was the position that they took because I thought that this order...
Counsel, why are we discussing this now?
For one simple reason. I asked if they were going to be conducting any further tests with the genes. Mr. Goldberg indicated to me that that could happen. I asked if they would give us notice of that. He said, I'll give you notice, but it's not necessarily going to be timely notice because I don't think you're entitled to that. And I said, well, if we want to have an expert present or document or even litigate any further alteration of these genes as to whether or not it's reasonably necessary for that to be done, particularly since we think that it shouldn't have been done in the first place, we want this court to order the prosecution to give us notice so that we can, A, litigate whether this should be done in the first place, whether there's reasonable necessity to do it under Griffin, and B, adequate opportunity to have experts there to do it. And I want to put the court on notice that we don't have full discovery from them. The test impressions that were actually taken
All right,
from the various objects we don't have.
Why don't you and Mr. Goldberg be here at 8:30, and we'll discuss the matter. All right, Mrs. Robertson, would you summon Mr. Goldberg tomorrow morning also at 8:30? All right, Mr. Harmon, are you going to conduct the hearing as to Mr. Sims?
Your Honor, actually, I believe I'm going to have some participation with the court's leave because we feel it is a hearing that is most appropriately bifurcated. Our position is that this evidence is clear rebuttal evidence. I was intending, with the court's permission, to tell the court, argue to the court why, in our judgment, this is clear rebuttal evidence, such that the timeliness of the RFLP testing becomes irrelevant. I did hear this morning, I know the court in a similar motion regarding scope of rebuttal was concerned about the timeliness of the photographs being collected and so forth, and I'm mindful that the court has expressed concern regarding the RFLP testing, but I would like to be heard as to why I believe, given Dr. Gerde's testimony, the evidence concerning the 303, 304, and 305 RFLP stains is true rebuttal evidence such that the timeliness issue with respect to case in chief falls by the wayside. We are certainly prepared with Mr. Harmon and Mr. Sims if the court wishes to hear the circumstances of the scheduling of the tests the chronology of events. Mr. Harmon is obviously intimately familiar with those and is in a better position to conduct the inquiry if the court feels that that is necessary. But I truly do believe that if the court hears what I believe to be the reasons why this is rebuttal, the court may be convinced that that hearing is unnecessary. Your Honor, as the court will recall from Dr. Gertie's testimony, he contested the reliability and validity of Mr. Sims's interpretation of the 1.3 allele in stain 31 from the Bronco console. As the court will recall, the testing on the PCR of that stain 31 was, in the opinion of Mr. Sims, consistent with a mixed stain of Mr. Simpson and Mr. Goldman. I believe 1.1, 1.2, 1.3, and a 4. The 1.3 and the 4 would be Mr. Goldman. Dr. Gertie's position was that the 1.3 allele was too faint to be legitimately called as an allele which was present. And in fact, it could be the result of cross-contamination due to sample mishandling.
Do you want to direct my attention to the particular passage in the transcript where
I
Dr. Gertie's...
think we can get that for the court. This is a summary. I had the issue framed in my mind in discussing rebuttal evidence with Ms. Clark, Mr. Hodgman, and so forth, and then I confirmed with Mr. Clark as to the substance of, and with Mr. Harmon as well, the substance of Dr. Gertie's testimony. But what I am saying is a representation made to me in my consultations with Mr. Clark, Mr. Harmon, as to Dr. Gertie's assertions as part of his testimony as a defense witness. And in essence, what he said with respect to that stain, in comparison, for example, with item 52, which was one of the blood drops on the Bundy walkway, which Mr. Sims did also see a 1.3 showing in the PCR testing, but which in that circumstance Mr. Sims felt could not be called as a true finding of an allele from a contributor, and in fact attributed it to an artifact. So Dr. Gertie's, one of his positions was Mr. Sims had to be consistent. He couldn't call the 1.3 in stain 52 an artifact and not call the 1.3 in item 31, the console stain, an artifact as well. The point is that stains 303, 304, and 305, combined under order of this court for the purposes of RFLP testing, come from an area nearby to where item 31 was found in the console. The RFLP tests, we have done now all 4 probes, but there is a report only of the 3 probe findings. The 3 probe findings are, again, consistent with a mixed stain of O.J. Simpson and Ronald Goldman. And further, they are consistent by intensity levels with the intensity levels found in item 31. The intensity level of Mr. Simpson's contribution being significantly more than the intensity level of the 1.34 allele called by Mr. Sims as consistent with Ronald Goldman as a contributor. So the essence of this RFLP test results from the 303, 304, and 305 stains is to undermine Dr. Gertie's contention that Mr. Sims was wrong to call the 1.3 and 4 a contribution by Mr. Goldman, but rather he should have called it an artifact, or to be consistent, it was an artifact through sample mishandling. We are corroborating with 303, 304, and 305's RFLP results, corroborating the accuracy of Mr. Sims's call on 31, accuracy which was called into question by Dr. Gertie's, a defense witness. And that's why this is true rebuttal, because we are now going to reinforce the accuracy of Mr. Sims after that accuracy has been attacked by Dr. Gertie's. Furthermore, Your Honor, I would submit to the court, as I know the court has had a concern and a requirement, that any time DNA test results have been given, there be population statistics given to the jury in order to understand the rarity or commonality of a particular finding. I submit to the court that on this RFLP series of tests, on 303, 304, and 305, the statistics are already heard by the jury. The statistics are the PCR statistics of stain 31, because we are not independently offering 303, 304, and 305 for themselves, but to prove the accuracy of 31's finding and the call by Gary Sims, as a result of which no further independent statistics should be required. And in fact, the statistics which have been received by the jury on the PCR, Mr. Clark was kind enough to give me the testimony, are much more favorable to the defense than any statistics offered by someone such as Dr. Weir would be for RFLP tests on 303, 304, and 305. For example, on stain 31, assuming 2 contributors, the statistics run from 1 in 4,700 to 1 in 19,000. And for the 303, 304, and 305 PCR stains, there's also been testimony as to these statistics. They run from 1 in 570 to 1 in 10,000. But if one gets into the RFLP statistics, and there was a recent report produced by Dr. Weir, which has been given, as I understand it, to the defense, for assuming 2 contributors, you are looking at a range of 1 in 58,133,000 to 1 in 114,237,000. Now, I don't hold myself out as the brightest guy in the practice of law, but it would seem to me pretty logical that if I were the defense, I kind of like the PCR numbers as to the commonality a lot more than I would like the RFLP numbers. And that's the point of this evidence of 303, 304, and 305. It is not offered for independent value, which may have resulted in it being in our case in chief, but it is being offered to corroborate findings that we did offer in our case in chief, which are basically similar findings. It's a mixed stain. It's a mixed stain consistent with O.J. Simpson and with Ronald Goldman, but it's now being offered to directly attack a defense expert testifying in the defendant's case in chief. That, as I understand the law, Your Honor, is true rebuttal. And for that reason, this evidence should be received, irrespective of when the test should have been or could have been performed. And I offer no opinion on the timeliness. I leave that to Mr. Harmon and Mr. Sims if the court still feels the need to hear it. But I suggest to the court, if this is true rebuttal, then we cannot offer this evidence until we reach rebuttal. We have reached rebuttal today. The tests are available today, and that makes them timely on rebuttal. As I also indicated, we submit to the court that no new independent evidence of statistics is required for the interpretation of these RFLP findings on 303, 304, and 305, where they are offered to corroborate the findings of PCR results on stain 31. Thank you, Your Honor.
All right, Mr. Harmon.
Oh, do I get?
They get to go first.
Oh, so in other words, you do want to hear from them?
Yes, I do.
Thank you. I'd like to just give you a little outline of the chronology, and then we can go through it with Mr. Sims if that's what the court would like to do. As the court recalls, on or about March 9th, you approved, over the strong resistance of the defense, our desire to combine these tests for to take whatever results came out of them, let the chips fall where they may. Other, I think, significant events, and Mr. Sims will go through the chronology in detail to demonstrate to the court that these things were processed in an orderly fashion. Mr. Sims made trips to Los Angeles. Mr. Sims attended study groups during this time period. Mr. Sims consulted with me in anticipation of his testimony. He also prepared reports, personally prepared the extensive discovery that's required. All of these things occurred at the same time he was trying to satisfy the desire to have these results produced as expeditiously as possible. As the court knows, during his testimony, there was a death in his family which disrupted his life. He took proficiency tests. His testimony was disrupted by that personal event. It's my opinion that the court, if the court is interested in any chronology, the most important part is the beginning. So I invite the court to stop me when you think we've covered the area that you're interested in. At some point, once the RFLP process has begun, and by beginning, I mean the hybridization. That's a misconception that the process begins when you begin the hybridization. Dr. Gerdes lauded the Department of Justice for their meticulousness. In fact, everybody played off LAPD against DOJ, and now you'll see as this hearing unfolds, they will be criticized for being as meticulous and fastidious as they were in making sure that even in spite of your approval of the combination, there were subsequent evaluations which, had they not produced favorable results, Mr. Sims would not have proceeded with the combination because it would have been against his scientific judgment to do so. But once the hybridization begins, and we'll give you some numbers on how long each probe was allowed to hybridize, essentially you're stuck with however long it takes to develop the results. Some of the key dates that I think to keep in mind in trying to identify, and I've asked every time we've addressed this issue, precisely what is the legal issue that we're addressing here? Mr. Scheck has consistently complained that we've denied them access to that evidence, and every time he's done that, I've said, no, the balance is still there. It's been there since March if you really wanted to test it. So that never was an issue. I think if they wanted to fashion a legal issue that somehow they were forced to proceed with their case without knowing what the results were, you will see that the chronology does not support that. The outline actually lists the date that the people rested, which is July 6th. The defense case began on July 10th, and if they complained that they were sandbagged, they didn't have to call Dr. Gerdes when they called him. They chose the date that they called him, and I think the court will see when you combine when they called Dr. Gerdes with what was known by the defense in order to fashion and very carefully craft or carve a way around the overwhelming biological evidence in this case, you'll see that Dr. Blake was, once again, a regular visitor there, was a regular reporter on the development of these probes. And as of the date of Dr. Gertie's testimony, the defense was aware that there were, in fact, 3 RFLP probes which produced the results that were produced in this case.
Mr. Harmon, maybe I can help you cut to the chase.
Sure, I'd like to do that, Your Honor.
What interests me most is the time period between March the 9th, when this court granted you permission to combine those samples for the purposes of attempting a single RFLP test, and the time that the test was actually undertaken.
Well, I think you'll see it was undertaken right away, but, you know, we're going to differ in what undertaking the test means. But I'd be happy to, because that'll bring us all the way up to August, depending on how you define undertaken. So we'll just start with March 9th, and you tell us when you've had enough, Your Honor. We've got the whole period of time covered. It'll take a while, but maybe we'll have our 5th probe before the hearing's over. So would you like me to have Mr. Sims testify?
Counsel, it's your record.
Thank you, Your Honor.
Madam Reporter, what's your time pressure? All right, proceed.
My name is Gary Sims, G-A-R-Y-S-I-M-S.
Your Honor, I've put my own chronology together, and I know Mr. Sims has reviewed it. These are my notes, but I don't have any problem sharing them with everybody. Would you like me to have a copy, Mark, as well?
Yes, for the purpose of this hearing.
Would you like a copy?
I would. Thank you very much. 613.
And Mr. Sims, have you had a chance to review People 613 for identification?
Yes, I have. That's the chronology of 303, 304, and 305.
Okay, and why don't we use the actual exhibit that's been marked? Is it your recollection that on or about March 19th, after some discussion and you filing an affidavit with the court, you received approval from the court over the defense's objection to combine what remained of 303, 304, and 305 for the purposes of doing RFLP testing?
Yes, that was about March 9th.
Okay, and did you actually conserve some of the samples? Are there still samples remaining to the best of your knowledge?
Well, yes, as I put in my declaration to the court that I would preserve sample on all of those, and in fact, I did preserve sample on all 3 of those samples.
And what did you actually do on March 9th?
On March 9th, one of the samples, 305, was brought back to the laboratory, and we spent a lot of time just documenting what was present in that sample, and then sampling it, and then repackaging for return.
Okay, how much time do you think you spent on that enterprise that day, March 9th?
It was probably the better part of the day. I don't know the exact number of hours.
Okay, March 10th, what did you do that day?
I had a meeting with you.
All day?
I believe that covered a lot of the day, yes.
Did you take Saturday and Sunday off?
I believe I did at that time, yes.
Okay, what did you next do with respect to this case, any aspect of this case, or specifically samples 303, 304, 305?
Okay, at that point we did, on March 14th, there was DQ alpha typing on that original sample of 303 and 304. In other words, prior to the time that they were combined. So at this point we wanted to know that independently they shared a consistent DQ alpha type so that we could then proceed with the further analysis. And that DQ alpha typing was completed on March 14th.
Okay, did you I think you misspoke. What were 303 and 304 previously typed with any marker?
Yes, they had previously been typed in D1S80, as I recall.
Okay, and why did you pursue the DQ alpha testing with 303 and 304?
Well, the DQ alpha testing was to, again, look for consistency of the results to see whether or not it was consistent with the mixture of Mr. Goldman and Mr. Simpson.
Did you obtain consistent results on 303 and 304 consistent with what you had seen in 305?
Yes.
Okay. Had you not obtained consistent results on 303 and 304 with the DQ alpha marker, would you have gone ahead with combining those 3 samples for the purposes of RFLP testing?
I would think not.
And why is that?
Well, because then there wouldn't probably be enough DNA of the people that may be involved in that mixture to get an RFLP result. In other words, they may be other people, and we've got an exclusion, perhaps.
Okay. So, as of March 14th, then, you had decided that even though you had the court's permission, that scientifically it was appropriate in your mind to go ahead with combining those 3 samples?
that I wanted to do that testing even though I had the permission. I still wanted to look at those DQ alpha types before I did the actual combination.
How much time do you think you spent on these tests on March 14th?
That's probably about a half a day's work, something like that.
Okay, do you recall if you did anything else with respect to this case on March 14th?
That's all my notes indicate.
Okay, March 15th, what activities did you perform with respect to this case?
On March 15th, I laid out in my notes what samples I still plan to extract in this case. I included these, the combination samples as well as some other samples in this case.
So were there actually other samples being evaluated and tested in this case during the same time period?
Yes.
And are they listed in your notes?
Yes, they are.
Okay, March 16th, do you recall if you did any work on this case or specifically the console stains?
I have nothing in my notes on that particular time. I should point out, too, that sometimes what I'm looking at here are my laboratory notes, and there are instances where I may be working on the case but not making entries in my laboratory notes. For example, I may be reviewing some of the other results or photographs or something like that, or consulting. That's not always showing up in these particular results, in these notes.
Now, just to jump ahead a little bit, did you have a report that you knew you were going to have to start putting together towards the end of the month?
Yes, there was the second big report we put out was in early April, and so we started getting ready for that also at this time.
Now, do you actually write in your notes getting ready to file report?
No, that's an example of the time, the kind of time that would not show up on my lab notes.
And the notes you're referring to, they actually reflect scientific or technical activities that you engage in?
Yes.
Okay, March 17th, what did you do on that date?
That was a time when we started some extractions on some of these various samples that we listed. This is when we actually, I want to make sure I've got the right set here. This is when we're actually doing the extraction of the combined set.
Thank you, Zach.
So when you say you're doing extraction, you can't use the DNA, or you're not using the DNA that you use for PCR typing. Is that true?
That's correct. At this point now, we're starting with the additional swatches to do the combination. In other words, we took those additional swatches that were from 303, 304, and 305, and we're extracting them now as a group.
As if you're starting the process from the very beginning.
That's right.
Okay. So you began the extraction on Friday, March 17th?
Yes, that was a Friday, I believe.
Okay. How much time do you think the activity that are reflected in your notes took?
I'm working on that at night, it looks like. The time I've got is, there's two different sets going. One goes in at 21:20 hours, another one goes in at 22:18 hours.
How many samples in each of those two sets?
There's about, I think, 7 or 8 in each one, something like that. 8 in one. I think 6 in the other.
And I assume you're taking your time?
Yes.
You didn't want to rush and be criticized the way Colin Yamuchi was?
Yes.
Want to be careful?
Yes.
Not have one tube open more than one tube open at a time?
I agree. Let's pick it up.
You meet with me that day as well?
Yes, on March 17th, that Friday.
How much time did we spend together?
I think we spent the better part of the day.
And so you spent the day with me and then did the extractions at night?
Yes.
Okay. Did you work Saturday on this case?
Yes, I did.
What did you do Saturday, March 18th?
On March 18th, I completed the extraction on some of these sets. No, I'm sorry, I did not complete it. I continued the extraction on some of these sets. And then it was on March 19th, Sunday, when the extraction was actually completed.
So you worked Saturday?
Yes.
How long?
Well, I have some additional notes that I may be able to...
Give us a ballpark.
I think it was a few hours on Saturday.
And how about Sunday?
That's probably some more time there. That's maybe at least half a day, something like that. It could be longer, I'm not sure.
Okay, and on Monday, March 20th, were you advised that the defense had filed a new motion challenging the DNA evidence?
Yes, I think I was aware the very day that it was filed, and I think that was on March 20th.
And soon thereafter, did we send you a copy?
Yes.
ask you to read it?
Yes, we decided that obviously that should be reviewed and discussed.
Okay, and did that ultimately take some time towards the latter part of March for you to review that motion and counsel us?
Yes, that was all part of the time.
March 21st, what sort of work did you do in this case?
Dr. Blake came over, reviewed some of the RFLP and PCR results in this case.
How much time did you spend with Dr. Blake that day?
I logged about 3 hours that day.
Do you recall if you did any, do your notes reflect specifically any other work you did on this case, on that date?
No, my notes do not.
Okay, March 22nd, did you again perform some specific hands-on work on the console mix in this case?
Yes, on March 22nd, I ran the yield gel on these particular samples, the Bronco console samples, as well as some of the other extracted samples in this case.
Okay, was there more than one set of samples upon or which you ran on the yield gel?
Yes, there were the two sets that I mentioned earlier.
So these are actually two separate yield gels?
It's what we call a double origin, where you take one gel, but you have two places where you enter samples, two parallel lines of slots.
And the purpose of the yield gel is to see how much DNA you extracted?
Yes, it tells you how much total DNA. It doesn't tell you whether or not it's all human.
How long do you think that this work on both of these sets of samples in this case took on March 22nd?
Given the number of samples involved and all that, it was probably the better part of the day was spent on that.
Okay. And then March 23rd, what sort of activities did you participate in with respect to the samples you'd process on the 22nd?
The main thing that I did on the 23rd was to go through and actually evaluate the results of the yield gel, and at that point I decided that I would want to do a what we call a blotting of the yield gel to see whether or not the DNA that was present was human.
And why was that important to you?
Well, it was important because, as we've talked about at length in this case, there were other samples where appeared to be a lot of high molecular weight DNA, but it was not of human origin. Some of it turned out to be not of human origin, and so I figured it was worthwhile to evaluate whether or not the DNA that we saw at the high molecular weight end, which is the RFLP-able type DNA, was in fact human.
Just to go back to the beginning, why was it your judgment, real briefly, to have to combine these three samples, 303, 304, and 305, for RFLP purposes?
Because individually, I didn't feel that there was enough there to get a good RFLP result, and I wanted to optimize the chances of getting a clear RFLP banding pattern, and to do that, I had to have more DNA to work with than any single one of those stains offered.
How much time do you think you spent on this case on March 23rd?
That looks like the better part of the day also, because there was the evaluation and then there was also the starting of the blotting process. My notes indicate I'm working on that latter part around 4 o'clock in the afternoon, and then I went overnight at 5:30.
Okay, Friday, March 24th, you met with me again?
Yes.
Better part of the day?
Yes, the better part of the day, as I recall, was spent meeting with you. There was a relatively minor part of the time spent in the actual laboratory analysis.
What did you do in that relatively minor part of the time?
That's after the southern blot of the yield gel went overnight, then I processed it and it was now ready to be hived and tested with a human probe.
What did you actually do that day, and how long did it take with respect to the console mix?
Well, what I'm doing is evaluating the yield gel I'm evaluating the yield gel to see whether or not the DNA on there was human on those samples, and so this is the part now where the southern blot has gone overnight and it's taken apart and then processed in a way that it's now ready to be probed to see whether or not there's human DNA there.
Okay, now this is not the RFLP probing, this is just to determine if it's human DNA.
That's correct.
How long did dismantling the southern blot take that day?
Well, I'm starting on that according to my notes, at 6:30 in the evening, so I believe I had spent most of the daytime talking to you, consulting, and then it's the latter part of the day then that I actually did this part in the laboratory, and that's probably about an hour's worth of work, something like that.
And when
Maybe
we talked,
less.
I'm sorry, and when we talked about this case all day?
Absolutely.
Okay. You took Saturday and Sunday off, the 25th and 26th?
Yes, I believe I did.
And did you perform any work on this case on Monday, the 27th?
No, I don't believe I did.
Okay, and March 28th, did you give a training session somewhere?
Yes, I was asked to participate in a PCR roundtable discussion in a training class at what's called ABI
What's that?
Applied Biosystems. They are a part of the company that actually produces these kits, the PCR kits, and they put on training classes for how to do this kind of PCR testing. And as part of their training course, they usually have an afternoon devoted to a roundtable type discussion of some of the issues that come up in courtroom interpretation, that sort of thing.
Okay, March 29th, you got back to the blot of the yield gel?
Yes.
What did you do?
At that point, I actually probed it with a human probe and produced what's called a LumiRad, which is like one of these autorads, but we're using a probe now that produces luminescence, and so you can actually read the intensity of these bands now to get an idea of how much human DNA is present in a sample on this particular gel.
And how long did that work actually take that day?
That would have been the better part of the day. I have my final film coming off around, looks like around 5:30 in the afternoon, something like that.
And so, I'll strike that. Did you perform any other work other than just getting that final film off, and was that it for that day?
Well, there's the whole hybridization process. I mean, that's done by the analyst, in this case me, during that whole course of the day, and you finally produce a film at the end of the day.
Okay, what I'm saying is when you ended up with the film, did you call it quits for the day?
Yes, I believe that's correct for March 29th.
Okay, March 30th, what did you do?
I attended the main thing I did that day was to attend a California Association of Criminalists DNA study group meeting.
Further education?
Yes.
And March 31st, you traveled to Los Angeles?
Yes, I came down here on that Friday. I spent all day down here.
That was an all day. And in my summary, is it true you worked about 115 hours on this case in March?
Yes.
And you were working on 5 other cases as well that are not reflected in this chronology?
That's correct.
You were back in Berkeley on April 1st on Saturday?
All right, before you move on any further, Mr. Sheikh, you want to consult with your client for a moment?
Your Honor, I'd ask, Mr. Simpson won't be able to eat.
It's a
if he doesn't
valiant
leave now,
effort.
so he's agreed to waive his presence for the remainder of the
All
hearing.
right, Mr. Simpson, is it agreeable to you that the court with the witnesses and the lawyers continue the hearing and you agree to waive your presence for the remainder of the hearing? All right. You're excused.
And how much time do you think you spent that Saturday on this case?
I think it was on the order of about half a day.
And Sunday, April 2nd, did you also work on this case?
Yes, I was involved in preparing the written report.
How long do you think you spent on Sunday, April 2nd?
I don't recall the exact amount of time spent.
Okay. Monday, April 3rd, did you actually do any hands-on lab work in this case?
The hands-on work was to actually now look at those LumiRads that I had produced from this human probing and to make an assessment of the results.
You did that? You did that on that date?
Yes, on April 3rd.
How much time do you think you spent on that aspect of this case on April 3rd?
That would probably be a couple hours at the most, something like that. That's not a lot of time.
Okay, and then April 4th, what sort of decisions or evaluations did you make in light of everything you've described to the court to date?
Well, that was the point at which in my notes I commented that, now I felt I had established that there was high molecular weight human DNA in all those, in the combined samples. I'd evaluated some other samples also, and in my notes on April 4th, I say, regarding 303, 304, and 305, proceed to RFLP.
Okay, did you also perform other work on this case?
Yes, Dr. Blake came over again on that day, and I also did some additional work towards getting the report out. And there was also some work on the discovery package at that time, too, so that was a pretty busy day.
Okay, April 5th, what kind of work did you perform on this case?
Report preparation also.
And then April 6th, did you and Renee Montgomery come down to Los Angeles?
Yes, I came down on April 6th with Renee Montgomery. I consulted with you, and I believe that was when the report was and the discovery package was delivered.
You actually hand-carried the material down here?
Yes, that's my recollection for April 6th.
Okay. April 9th, a Sunday, what did you do on that date with respect to this case?
On April 9th, there was some consultation with you on that Sunday, and there was that was the main thing that day.
Okay. April 10th?
Yeah, yes, on April 10th, I think I may have misstated on April 6th. I'm not sure I delivered the discovery package on April 6th. I think it was just the report that actually came down on April 6th, because I noted that there's more discovery going on as we get into like April 10th and April 11th.
And so you continued to work on the discovery after you filed the report?
Yes, I think that's correct. I think I misstated that the discovery was delivered on April 6th. We could check that.
Okay, and the outline that we've prepared lists discovery prep on April 10th and April 11th?
Yes.
No actual laboratory work on the console mix in this case, is that true?
That's correct.
And then April 13th and 14th, you've listed preparation for testimony?
Yes, at this point, I began in earnest to prepare for the upcoming testimony, which I anticipated could be at some time in either the end of April or in early May, something in there.
And why'd you decide to do that instead of continuing with the RFLP testing at that point?
Yes, well, there are two reasons. One is that there was a large volume of material that I felt I needed to be responsible for. In other words, that I had to be prepared to be cross-examined and also to present direct testimony on a large number of items, a large number of typing results. And also, I wasn't sure what sorts of issues might be raised by the defense based on that motion of March 20th. So I prepared in earnest to get all the literature articles in order, that sort of thing, review as many of them as I could, and then also to have plenty of time to study my own notes, just the actual notes in this case, and not just the other issues involved.
You take Easter Sunday off?
Yes, I did.
Okay. The next week, April 17th and 18th, did you continue your preparation for trial testimony?
Yes.
The 19th and 20th as well?
Yes, I believe on the 19th there was some additional analysis as far as just reviewing results.
But
But
no actual,
nothing in the lab.
No lab work?
That's
Okay.
correct.
You took April 21st, Friday off?
Yes, that was when my kids had a school holiday that week, and so I took that Friday off.
Okay. Then the following week, on April 25th, did you actually get back to discussing specifics on the console combinations in this case?
Yes, I decided at this point that I would try to get that RFLP work going, and that was April 25th.
What did you actually do on the 25th?
On the 25th, there was I outlined in my notes what sort of results we had on the, this goes down not just the 304, 305, that combination sample, but also the other samples that were being extracted and evaluated at that time. But there were decisions made as to whether or not some of those other samples should go through what we call the slot blot process, because in other words, there was not enough human DNA in some of those to detect it on a blot of the yield gel, so we had to do an additional test for human DNA on some of those samples. So I made some notes there. I provided some extracts to Renee Montgomery for her to proceed with that. And then also on that 25th, I actually began to outline how I would do the RFLP, to plan the RFLP on the Bronco console.
What sort of planning do you think was entailed in that?
It was a fairly involved process because of the limited amount of sample that was available. It involved looking at those reference samples as well as the combined console samples now, because that I basically knew what I had to work with. At that point, I knew I had about 72 nanograms total available from that console, something like that. I knew that given that low level, and I also knew that it was a mixture of samples, so that told me that I had a very low level of DNA to work with. And in trying to balance an RFLP gel, one wants the samples to be in fairly good balance so that the bands are not blown out on some samples and then very weak on others. And so as part of that balancing act, I had to go through what I had of the reference samples from the defendant, from Nicole Brown's, and from Ronald Goldman, and to evaluate how much of those extracts I would use to do this restriction analysis.
Did you also continue to prepare for your testimony on that day?
Yes, I believe there was also some time spent on that day doing that, too.
How about the 26th? What sort of activities did you do with respect to this case on that date?
On the 26th, I actually got the tubes out. After having planned it the day before on the 25th, I got the tubes out on the 26th and checked them to see if there was enough sample on these. Because on some of these now I was running out of sample. For example, on the defendant's extract, I was getting low on the sample that we had from one of his swatches that had been extracted. And so I had a note here that I needed to check this previous reference extraction sample and see if there was enough of his extracted DNA to get a sufficient quantity to put on this RFLP gel.
How much actual hands-on time was involved in this on April 26th with respect to these samples? The ones he's talking about on the 26th.
We're not talking about console samples. He hasn't been for a while, so.
You're talking about, as far as the reference samples and
The
that?
26th, all the samples.
Yes, that's the thrust of what I'm doing at that point. This is, it's again, it's difficult to say just looking at these notes, but it's probably about a half a day, something like that.
Now, you're going to run these reference samples with the console mix, right?
That's right. In other words, they're going to be restricted at the same time, and they go through the whole process at that point together.
Okay. How about the 27th? What did you do that day?
There was preparation for testimony on the 27th, and also I attended a study group meeting for the California Association of Criminalists.
Further education?
Yes.
Okay, Friday, the 28th of April?
Yes, on the 28th of April, as I'm looking at my notes, in the interim, Renee Montgomery had run a slot blot analysis of some of these other samples, and this doesn't relate now to the center console. This relates to some of these other samples that were extracted at that time. And I went through with her the analysis and the quantitations on those samples. Dr. Blake came over that afternoon. We spent about 2 hours reviewing some autorads as well as the quantitations.
Okay, and then you met with me as well?
Yes, I met with you on April 28th, Friday also.
Now, these other samples, these are not the console samples, right?
That's correct.
But there are other samples in this case?
Yes.
There are other samples that could have tended to incriminate or exonerate Mr. Simpson?
Yes.
The summary notes for April reflect that you were working on one other case during that month. Does that sound right?
Yes.
And you worked about 108 hours on this case?
Yes.
Okay. In May, Monday, May 1st, what sort of work was done by you or Renee Montgomery with respect to this case?
On Monday, May 1st, Renee Montgomery reran some D1S80 samples.
Okay. Did you actually do any lab work on this case on May 1st?
No, I don't believe so.
Okay. May 2nd, what sort of work did you do on this case on May 2nd?
The one interjection I wanted to make when you asked me if I did any other lab results, keep in mind also that during this whole process we are developing autorads, for example, and that is some time that's involved as far as developing and looking at them and deciding what kind of exposures we're going to use, and that's not reflected in any of these lab notes.
And there's no way to reconstruct that, is there?
Not simply, no, but it could be done, but it's not simple. But that's part of the process that I haven't addressed any of that's going on as we're doing all of this.
Okay, May 2nd, what kind of work did you do?
Again, at this point, I'm very much in the preparation mode. I put together, I worked on the what we call the photo log of keeping track of all the photographs that were taken.
May 3rd?
I have 6.5 hours of preparation for testimony.
May 4th?
I have 8 hours of preparation for testimony.
May 5th?
May 5th, in my notes, I indicate that I'm working with Renee Montgomery again on some of these additional samples.
In this case?
In this case, right.
May 6th, Saturday?
Yes, May 6th, Saturday, May 6th, which was Saturday, I again spent some time in preparing.
And May 7th, you came down to L.A.?
Yes, that was on Sunday. I came down to Los Angeles.
With Renee Montgomery?
Yes.
And how long did you stay in Los Angeles during that segment?
I was there from Sunday to Friday.
And what was going on that week?
That was the time at which Dr. Cotton was testifying, and I was monitoring her testimony.
Now, in your laboratory, you don't have underlings that actually do bench work for you, is that correct?
Well, that's correct. The only thing that we have as far as having other people working with us, I wouldn't use the term underlings, but they are people that are, for example, involved in the batch probing process.
Okay, so when did you return to Los Angeles?
It was on Sunday, May 14th.
And then what were you doing those weekdays that you were down here?
Well, on the following weekdays, 15th was a Monday I was standing by for testimony. And my testimony actually began on Tuesday, May 16th and went through Friday, May 19th.
Okay, and there was a death in the family?
That was on May 19th in the evening.
And did that interrupt your testimony?
Yes, it did.
And when did you return to the Bay Area?
Well, I returned to the Bay Area on...
Counsel, this part's all part of the court's recollection as to these events, these personal events in this proceeding. Let's move on.
Sure. We're up to the end of May, the summary.
Yes.
You've listed 172.5 hours on this case, and you worked on no other cases during the month of May. Is that correct?
That's correct.
You completed your testimony on June 1st?
Well, that's not strictly true because I did testify later in June also, as I recall.
For that's
But that segment,
that
yes.
segment of your testimony. On June 6th, you again returned to working, the actual bench work on this case, is that right?
Yes.
Okay. Now, would you describe what the next steps of the process entailed and why you had to wait so long to begin them, if you did? You've described everything up to this point and everything else that you did. What would the next steps in the process be, and why didn't you do them before?
Okay. The main steps in the process would be the restriction analysis, where you actually restrict the DNA, and that goes overnight. Then the next step is to purify and reconcentrate that DNA and then set it up on the actual electrophoresis, the analytical gel, and that goes over another night. Then the next day, one would do the southern blot, and then that would go overnight. And so there's a series of events that take place. Specifically, once the analytical gel is put into motion, and that would be like towards the end of one day, then there's a time period where you basically have to follow up at certain precise times. So for example, you could do the restriction and then put those samples aside and then do the electrophoresis at a later date. But once you start that electrophoresis, then you're tied into a 3-day period.
Well, is that just the way you do it, or is that the accepted protocol?
I believe that's pretty much standard protocol in most RFLP laboratories.
And having that need to, once you get started in the process, to do it continuously, did that affect your ability to do it during the month of May?
Well, certainly May was very much disrupted by the testimony and being in Los Angeles.
Okay, so on June 6th, then, what did you do?
June 6th was back in the laboratory. I think there's some review going on at that point and discussion perhaps, and then it's actually June 7th when I set up the actual restriction.
And did that continue over to the 8th?
Yes, the restriction went overnight from June 7th to June 8th.
And then June 9th, you took the day off?
Yes, this was at a time when my children were out of school, and I took that day off.
And the weekend? You didn't work Saturday and Sunday?
Yes, I was ordered not to work that weekend, as I recall.
June 12th, you came back to work, and you've listed 2 hours of analysis. What did that entail?
That may have been some actual evaluation of autorads at that time. I don't have anything in my working notes about June 12th, so I believe that's probably some evaluation of autorads that were coming off.
All right, Mr. Harmon, 10 minutes.
Okay, we're just getting to the good part, Your Honor. Good. June 13th, you set up the analytical gel, which actually produced the autorads in this case. Is that right?
That's correct. In other words, that electrophoresis went overnight, June 13th.
Set up the southern blot on the 14th.
Yes, and that went overnight.
On the 15th, the membrane was ready for hybridization.
That's correct.
And when did you actually begin the hybridization process for that first probe?
That would have been June 15th.
And how long did that probe hybridize, or how long did you allow it to hybridize to produce a result?
That first probe was for locus D2S44, and that went 19 days until it was completed.
Why did it take so long?
The results were weak.
Okay, and then did you soon thereafter begin probing with a different probe?
Yes, the next probing was for locus D4S139.
And how long did that probe, was that allowed to hybridize for?
That went 12 days.
To the 19th?
Yes, I believe that's correct.
And then what probe did you begin with after that?
Then the next locus was D5S110, and that went 9 days to the 5th of August.
July 27th to August 5th?
Yes.
And then the fourth probe, which is, what's the designation of the fourth locus?
The locus is D10S28, and that went from, that was a 10-day exposure from August 26th to 9/5, September 5th.
And you actually have a fifth probe hybridizing as we speak, or hopefully?
We have a film sitting on a hybridized membrane as we speak.
Okay. I think I've covered it. Thank you, Your Honor.
What's your guess as to when that one might be ready? This last one.
I was planning on looking at that tomorrow, is when I have it designated for the first film to be looked at. And then at that point, I make an evaluation as to how much longer the other film I don't know if this is new material, but the way we do it is we have a sandwich with the membrane in between two films. We look at the top film, which is called the non-DNA film, first, and that gives an idea of how it's developing. And then we make a decision at that point as to how long the final film will stay on there.
I just have one other question. Was Dr. Blake alerted every time you had a new autorad to see, to give him an opportunity to come over and take pictures of it?
Yes, I kept Dr. Blake informed of that. The only one I don't think he's aware of is this this fourth one, but I provided that in discovery last week when I was down here on Thursday.
Mr. Schick?
How long?
I'm sorry?
I'll try to be brief, but I'm mindful that
Yeah, we're going to
way
quit
over
it.
the limit.
We're going to quit at 6:30. Sorry. But we'll start at 8:30.
Well, I'll see if I can get right to the point.
Okay.
Mr.
Not
Sims.
today, sir. This is a good time. This is a perfect time. They're going till 6:30 today, but we aren't. So, we're done. We got far. We're doing great. We are right on track. We are on video 447. We are on the last part of September 11th. And then, remember, this was just Monday. So we still have 12th, 13th, 14th. We don't skip for 4 more days. So, 4 more video days, not 4 more hour days. It's going to take us a while. This is a healthy week. Like, this is the next day that we're going to, September 12th, 4 parts. The 13th, 3 parts. The 14th, 3 parts. And then the 15th is only 2 parts long. I guess they got out early on a Friday. So, and remember, the trial is over. Wow. October 3rd. So, wow. We're so close. I don't even know what to do with myself once this is over, you know? No, we're not starting another trial right away. We're just absolutely not. But it'll be weird, you know? All right, guys. Thanks for coming out. I appreciate it. I shall see you all again very, very soon. Tonight, 8 o'clock. Bye, guys.